Welcome back, viewers, to the PI show. It's that time of the show where we've got Viv's mailbag, but the stand-in is Beth Alston. Beth,
hi, Tony.
You enjoyed it?
Yeah, definitely. Thanks for having me tonight, guys. And it's been a great show so far.
Thank you.
And we've got some interesting questions from our viewers. The first question is from Rick in Pakenham. G'day, guys. I'm a painter in the sense that I paint houses. And although I work for my bosses and get paid by the hour, I'm classified as self-employed and have my own ABN. If I was injured at work, is there any chance I could get work cover benefits, even though I'm not considered an employee? Now, Tony, there's a lot of workers in Rick's situation who have their own ABN. Does that make a difference to work cover?
Yes, it depends on whether you're working for the same people all the time. If you're working for a particular person on a regular basis, you might be what they call a deemed employee. And that happens a lot with courier drivers and truck drivers and things like that. So it might be a situation where he might be deemed, which gives him a lot of entitlements as against the people that he's working for no-fault benefits, and then subject to the circumstances, you might even have common law benefits down the track. So there's a number of issues to look at. One, is he a deemed worker? And if he's not, then you'd think he might be a company, set up as a company, so he might have work cover insurance. So, yeah, no, you've got to look at it carefully. I think there might be some benefits there, but
so
you need more
facts.
So
the fact that he's paid by the hour, does that have any difference?
It can, but I think the real issue is how often does he work for these particular people? If he does it on a regular basis, consistent basis, then I think he might be deemed. Is that what you think, Eric?
Yeah, look, these cases, as Beth says, a lot of people are in a variety of employment situations or contractors and subcontractors, and in the building industry, often they're what's called captive subcontractors. So they go from site to site, but they're working for one person who provides all the work. So
that's where the deeming provisions kick in, and that's where the deeming provisions.
So in effect, although you're an independent contractor, that you've got an ABN number, and the tax office allows you to do that, you are captive to a major contractor, and that contractor supplies you with work. So they will ring up and say, "We've got a job for you in Pakenham, we've got a job for you in Cranbourne, we've got a job for you in a variety of places around Melbourne. Could you please go there and work?" Now, that's a situation, you are a deemed worker and you're entitled to statutory benefits. So you've got medical expenses and your weekly payments covered. The rate of pay is what determines your entitlement to weekly payments. However, at the other extreme, if you're a painter and you go from site to site, then you've got to have your own insurance. If you've got no continuity with any one person, you've got to have your own insurance.
Difficult set of circumstances. Difficult set of facts. I think should get proper legal advice.
So if there's an injury on a building site, it's terribly important to get independent legal advice about circumstances of injury and what your rights are. There's also issues about superannuation and whether you've got any benefits under superannuation policies.
And you might even have income, which is pretty important.
Yeah.
Okay.
All right, we better...
Oh, that's interesting. Well, the second question is from Cindy in Caulfield. To the PI show, a few years ago I had my appendix removed. Even though the operation went well, I wasn't diagnosed with having appendicitis until it was almost too late, and I was told by my surgeon that I was minutes away from my appendix bursting. Because of the late diagnosis, I suffered more pain and for longer than I otherwise would have. This stopped me going to work, and I was so traumatised that I've been on antidepressants ever since. Do I have a claim against my doctors? Well, Harry, you've worked in this field. You probably know the answer to this question.
There's no simple answer. It depends on the facts as well. The misdiagnosis can be the subject of a claim. However, it doesn't sound to me as though there's any permanent injury that's arisen from the misdiagnosis.
Well, if she's on antidepressants,
there's antidepressants, and that
have
may...
a psychiatric injury, perhaps?
She might have a post-traumatic type condition
that may continue, but you need to have an impairment permanent of more than 10%.
Okay.
Now, that's a difficult hurdle to get over.
Well, Harry, foreseeable future, It doesn't mean, 20, 30 years into the future. It's as far as you can forecast into the future. So
but in my view, it's a difficult hurdle to get over. And the fact that there was a misdiagnosis that didn't result in permanent physical damage, if you like, means the claim would be difficult to get off the ground. But look, you've got to get into the facts and the situation and
need a few more facts, perhaps.
What happened?
Yeah, sure. Okay, we'll get to our last question of the day. This is from Tracy in Dandenong. Hi guys, there have been heaps of news coverage about the supermarkets stocking items that are past their use-by date. What would be the liability of the supermarket if someone got sick for eating, for example, an overdue dairy product? Is there any onus on the consumer to ensure that they aren't buying products that's past its use-by date? Thanks, Tracy.
I think the liability question speaks for itself. If it's past its use-by date, there's got to be a reason for it. The reason why you've got a use-by date is to ensure that you don't have these scenarios where you're consuming products that might be considered,
defective.
Defective, yeah.
You've got rights under the Trade Practices Act for defective products, and then you've got a common law right as well. Many years ago, there was people got sick from Kraft peanut butter bought off a supermarket in a particular area, and I think there was what's called a class action, and Kraft early on in that action spoke to the other lawyers and said, can we please get together and resolve this claim? So they admitted
liability. The pork roll, sorry, do you remember that?
There were pork rolls in a particular area.
Yeah, that was
Sorry, Harry, was the peanut butter past its use-by date? Was that the cause of
well,
action?
it was a defective batch.
Yeah.
Right,
I think they conceded that it was a defective batch for peanut butter, and there was about 60 people affected.
I think the answer for Tracy is, look, there's liability there, and the next issue would be, what is the damage? It comes back to the principles under the Wrongs Act of,
But you don't need 5% under the Trade Practices Act. You need some damage.
Yeah.
And with the Kraft peanut butter, what happened was they had an independent QC just assess damage individually based on all the medical evidence. So some people just were sick for a day or two, others had longer term effects, and the QC would assess independently and it bound both parties on the quantification of damage. So it might be 5,000, 10, 50,000, 100,000, depending on the seriousness of the injury.
Harry, we're going to have to wind up the show. Look, it's been fascinating, Beth, and I think we should encourage the viewers to keep
Thanks so much for the
sending
answers,
in
guys.
questions.
And keep sending in questions. We love your questions. Just send them into the pishow.com.
Yeah, look at our website and send in questions. And thanks for watching. And we'll be back next week with regards to Viv.
Yeah.
She's doing well.
Thanks, Beth. Harry.
Thanks, Beth.
Thanks,
Viewers,
guys.
keep watching. Stay tuned for next week.
Thank you.